Good afternoon, everyone. I'm Simon Bevan and I'm a partner at VWV working in the Employment and Safer Recruitment team. I'm joined today by a couple of our stars, so thank you to Joanne Oliver, who's a partner who's increasingly working with independent schools, and with Jessica Scott Dye, who is our professional support lawyer, who is amazing and will be managing our panel discussion and questions to the extent that we're able to do that. We do have lots of material. There are lots of slides. I do hope you will all be able to review those in the cold light of day and share them with colleagues and discuss how you will consider approaching the issues that have been raised in the Supreme Court judgment in the Brazel case. In answering questions, we will of course be dealing with broader principles, but you will all need to review your own contracts and go beyond that and look at the calculations you have actually used in calculating holiday pay for certain categories of staff, which we will review and consider today. So that's the overview of the things we will be considering. Moving on, please, to our first slide, we're setting the scene. Now, in setting the scene, you'll all be aware from the slide there that holiday pay was introduced as a right through European Union law, and it was added to by domestic law, so that now we have a situation where all staff are entitled to 5.6 weeks of holiday leave and pay, for each week of leave you'll be paid a week's pay. So what does that mean? Put simply, if you're a full-time member of staff who works all year round, well then you will have a weekly pay rate, and when you take a week's leave, you will get paid a week's leave for that time. So if you're full-time and you earn £200 a week, when you're on holiday, you will be paid £200 for that leave. Prorating of holiday pay for part-timers, we need to move away from that terminology. And when we're looking at the week's pay, you'll see that if you work part-time, you're entitled to the same amount of holiday leave, which is 5.6 weeks leave. But of course, as you're working part-time and earning half the amount as the full-time and working all year round, you will earn £100 a week and you will be paid £100 when you're on holiday. So the good news is for full and part-time staff who work all year round, the Brazel judgment doesn't have any impact on their leave entitlement or their leave pay. That's relatively simple and has not changed. So looking at the slide here, we need to understand why the Brazel case became an issue and why it went all the way up to the Supreme Court to be challenged. And I think it's worthwhile pointing out in the first instance that this was not a case seeking to deprive someone of holiday leave or pay. It was more about fairness and ensuring that everyone gets the same amount and the same benefit from holiday pay and leave. So when the working time regulations were first introduced, both ACAS and the government guidance reviewed what you would earn as a full-time or part-time worker worked all year round and came up with this percentage method of calculating what holiday pay someone should be paid if they worked more atypically. So part year, casual, term time only, VMTs, invigilators. So the way you could say, we want to treat you the same way as our all year round staff, the 5.6 weeks divided by the balance of the year, the 46.4 working weeks, times 100 gives you a holiday pay entitlement of 12.07%. That was considered the fair way to provide everyone with a similar amount of benefit, the same amount of benefit. And we say here that it's the sector standard, but it's not just the sector standard for independent schools. It was for maintained schools, for care staff, hospitality staff, retail staff. It was the method of calculation which was considered the fairest of all. And it's what we refer to as the pro-rata principle. So this was challenged, and it was challenged really on the basis of the provision of the legislation saying, the working time regulations saying that you should be paid 5.6 weeks at your weekly pay rate. So on the face of it, that's what full and part-timers get. But if you think now in terms of percentages, and we haven't put the percentage on this slide, if you only work 32 weeks a year, and so you then use, looking at the top of the slides, the first bullet, if you were to say 5.6 weeks and you were to divide that by the 32 weeks that you work, well, then that would produce a holiday pay percentage of 17.5% holiday pay. So Mrs. Brazel's case was that because of the wording of the regulations, she should be entitled to a 17.5% equivalent calculation rather than the 12.07% that everyone else would be receiving. So if you look at this as an extreme, if someone was working term time only for you and they just worked one term, so they worked in, say, the summer term as a sports coach, as a cricket coach, well then if you were to use that same calculation, 5.6 weeks, and divide it by 12 weeks, well then you would be paying a 40% percentage increase to make sure that that they got the same, that they got that 5.6 weeks holiday pay at the normal percentage. So this does seem very unfair, and it's why this case proceeded all the way to the Supreme Court. So just whilst I'm using percentages here, this is just to set the scene. Of course, what we now know from the judgment is that we won't be using percentages anymore, except at times to sense check some of our calculations. So the pro-rata principle, full and part-timers who work all year round, you can prorate their salary, benefits and holidays. But if you work part of the year, what you cannot prorate for the number of weeks, only for the hours and days, but not prorate for the number of weeks that someone works. So we've got a poll now for you all, please, on the next slide. And that poll is, what is the impact of the judgment, do you think, on you and your school? So the Supreme Court, in providing its judgment, described the result as giving a slight favouring of workers with a highly atypical work pattern. Do you agree that it's so straightforward? And I can see the poll is now open. So it's a slight favouring of workers. I would be interested to see your views, please. No, well, I can see that 80% consider this to be a much more difficult situation that the Supreme Court considered and explained in their judgment. And I have to say, I very much agree with that. The implications are much greater. So following the Supreme Court's judgment, all staff are entitled to, well, all staff who are employed on a permanent basis, so on an all year round contract, whether they work term time only, part-time, casually during that year, they're entitled to a full 5.6 weeks holiday pay. So we can no longer apply a percentage. So I referred already to the 12.07%. We cannot use that anymore. And you can no longer prorate the number of days on of holiday pay. So for example, if someone worked for half of the year and they were on they were on a contract, a permanent contract that continued, you couldn't prorate the number of days or weeks holiday they have to say, well, you work half a year. If you work the full year, you get 5.6 weeks holiday. If you work half the year, you get 2.8 weeks holiday pay. So you cannot do that prorating anymore. So this may mean that you are going to review those contracts where someone doesn't work all year round anymore, and you may be looking to reduce them. You may be looking to change the basis upon which you contract with them. But this judgment meant that by granting a full 5.6 weeks holiday leave and pay to Mrs. Brazel, working a 32-week per year, she will get 17.5% holiday pay on the basis of that judgment and her current contractual arrangements. So let's be clear on the entitlement here then. So we need to look at the wording. The reference here is to the Employment Rights Act. And so if you work normal working hours and get the same monthly pay each month, then you'll get a week's pay when you're on holiday for a week. And so you will get a full 5.6 weeks paid holiday if you are salaried in that way. You may already get it, by the way, but that's what you will get. And that doesn't matter if you work 38 weeks a year, 32 weeks a year, even 26 weeks a year. If you're employed all year round and you have a different work pattern like that, you will get a full 5.6 weeks paid holiday. So that's one category of staff that we have to think about, those salaried in that way. What about those with no normal working hours? Well, in that situation, and that may apply to VMTs, casuals, invigilators, sports coaches, for example, well, then they will get the average of a week's pay for each of their holiday weeks, each of their 5.6 weeks holiday pay. And Joe is going to talk to you about how we calculate that week's pay in just a moment. As a small aside, you may be amused to note that two of the QCs who were involved in this case were both friends of mine when we were at University of Manchester together. And during the time that this case ran, they both became Deputy High Court judges as well. Well, the current contract for a Deputy High Court judge it's a permanent contract, but you only have to work 4 weeks per year to remain on the roll. So on the basis of this judgment, and we argued strongly that this was a nonsense, they would now get a 5.6 weeks holiday entitlement if they worked their straight 4 weeks in that year. So looking at that as a 5.6 weeks holiday divided by the 4 working weeks that they do, that would give you an uplift of 140% of the pay they would receive as holiday pay. So I suppose that's nice work if you can get it, but it does just show why this case, it was so sensible to try and dispute the way the Court of Appeal had made their judgment, and to try to see if good sense would prevail. So now we're looking at does the ruling affect teachers? Well, you'll be very pleased to know that this is one of the areas where we can give you certainty. Teachers are employed all year round and get paid for holiday with pay. So no, they will not be affected by this judgment. But I just wanted to make you aware, actually, the day after the judgment, I was listening to the Today programme on Radio 4 the day after, and at about 6:20 when they had the business news on, there was a partner on the show from a large law firm explaining to anyone who was listening then that this judgment would affect all teachers. So I think you have to be very careful as to the sources of information that you go to, because that advice was incorrect. But you will need to understand that other people may be giving incorrect advice and your staff may be hearing about it. So don't be surprised if you haven't had already that in September, when all staff come back, you may be getting questions from people who this doesn't apply to, and you need to make sure that you're ready with your responses to all the categories of staff that you employ. Another point on which I can be clear is that we are talking about statutory holiday only here, the 5.6 weeks. And often staff may be given more. And I know there's it is common in a school environment, someone may be given 6 weeks, 6.6 weeks, for example. Now, you're not entitled to prorate the 5.6 weeks, but you need to check your contractual wording. But if you provide for an additional amount of contractual leave, but then you've prorated it all down, you still may be able to prorate the contractual entitlement in the contract, so long as you don't drop below the 5.6 weeks. And this may apply to visiting music teachers, term time only staff, casuals, etc., if in their contract you've provided them with an additional amount of leave. So it is important to check that, because on the face of it, even though you may prorate the statutory holiday entitlement and prorate the contractual, you still may be able to prorate down to the 5.6 weeks, of course, depending on your contractual wording. So I've already covered this slide, haven't I, about prorating for part-time staff. And for part-time staff, I mean the all year round ones. So I've already mentioned this, and it's about the calculation of a week's pay. So you can't prorate the amount of holiday that they have. What you do is by saying, because you're paid a week's pay when you're on leave, if a full-timer is earning £200 a week, you work 50% of their time, well, then you will get £100 when you're on when they're on their annual leave for a week. So I hope all of that's clear so far, and I'm now going to hand you over to Jo to deal with some of the more technical points.
Thanks, Simon, and good afternoon, everybody. As Simon's already covered how much holiday or statutory holiday an employee or worker is entitled to if they work part of the year, I'm going to talk through some of the calculations for how you arrive at what a week's pay is based on what kind of work an employee or worker does for you. So the starting point here is the working time regulations, which say that a worker is entitled to be paid the rate of a week's pay in respect of each week of annual leave that they take or are entitled to. So the question then is, how do you calculate what a week's pay is, especially if a member of staff's pay varies depending on the type of work they do or the hours that they work? So we then turn to the Employment Rights Act, which sets out 4 different methods of calculating a week's pay based on the worker's hours and how they're paid. So the different methods cover 4 different categories of staff. So we've got workers with normal working hours with pay that doesn't vary. And for most of you, that's going to be your term time only TAs. And then we have workers with normal working hours with pay that varies according to how much work is done. So that's not something that really is going to be applicable within the school sector. That's for piecework, so production kind of work. And then we've got workers with normal working hours with pay that varies according to, then we've got workers, with no normal working hours and pay that varies depending on how much they work, and their pay can vary from week to week. And that's the type of work that Mrs. Brazel did as a VMT. Her work would fluctuate depending on the demand for the instruments that she taught, and her pay would follow that demand. And so from week to week, her pay would vary. And that might cover your other casual workers. So sports coaches and vigilators would be in the same situation. So if we look in a little bit more detail at workers with normal working hours and pay that doesn't vary. So as I mentioned, that's going to be your term time only TAs who work a fixed work pattern, week in, week out during term time, receive the same pay every week for the works that they the weeks that they work. Sorry. And so when you're calculating that, you would look at the number of total working weeks in their working year, so the term time weeks, so that might be 32, 39 weeks. And then you would look at their statutory entitlement that the Brazel case has settled as 5.6 weeks holiday. And you would consistently apply the same rate to the total number of those weeks. So here on the example, we've got 44.6 weeks of pay. And with these members of staff, you would annualise their salary so that they receive the same amount over 12 equal instalments throughout the year, so they've got consistent pay throughout the year, and that there is not a drop off during holiday times. And so when they're taking their holiday, in holiday periods outside of term time, they're receiving normal pay during that time. And we look at the staff who have no normal working hours. So those on 0 hours contracts or variable hours staff, and how we calculate their pay. Because this fluctuates, it's harder to do. And the Employment Rights Act has a method of using a reference period. So you work out what average earnings might have been per week. Initially, that was a 12-week reference period, but recently that was updated. I think 2020, that was changed to a 52-week reference period. And the purpose of that change was to remove the potential for unfairness, where you might have seasonal workers who have high demand at particular parts of the year, low demand for their time at other parts of the year. And when their holiday calculations were done, it may be that they were detrimentally affected by having worked fewer hours in the lead up to that period of holiday. So with that in mind, and with a review of some wider worker rights, a 52-week reference period was brought in. And so you would calculate that over weeks that the member of staff had worked. You would ignore any weeks where they haven't been paid, where they haven't worked, and substitute those weeks with a further week, so that you've got a total of 52 worked weeks that you're taking your average from. If you don't have worked weeks for that 52 weeks, you can extend that out to a 104-week period maximum, where you would take worked weeks to add into your average calculation. And that would bring up what a week's pay is, and that would be multiplied by 5.6 to create their entitlement for the year if they took their full period of leave at that particular point, or you do the calculation at the point that they take the allotted amount of leave that they are asking to take, or that you've assigned under their contract that they should be taking in holiday time. And you would calculate the reference period from the point where they're due to take the holiday, working backwards from that date. If we move then onto the next slide, please. So how do we calculate holiday pay for salaried term time only staff who also work occasional overtime? Now, overtime has been the subject of quite a lot of case law in recent years, and whether overtime forms part of someone's normal weekly pay. And through those cases, it's been established that where you are working mandatory overtime that is compulsory, that would become part of normal pay, because there is an expectation that you're doing it, you have to do it, and therefore that employee should have the benefit of that rate of pay when they take their holiday. In circumstances where you've got a term time only TA, for example, where they might do a small amount of overtime on an ad hoc basis, then that voluntary overtime isn't likely to be included as normal pay. It's an ad hoc, loose arrangement that happens from time to time and is not therefore their normal pay. But you just have to be careful thinking about a situation where that ad hoc arrangement becomes more routine, becomes more normalised. And in those circumstances, if it starts to be part of their pay on a week in, week out basis, then there's going to be an argument on their part that that becomes their normal pay and should be taken into consideration for their holiday pay calculations. So if we now look at the impact on casual staff, and one of the questions that we've been consistently asked since the Supreme Court decision came through is, should we as employers be changing the way in which we enter into contractual relationships with casual staff? Should we be looking at putting in different methods of engaging with individuals? Should we keep using casual worker contracts that go on throughout the course of the year? Or should we be looking at something else that would limit this potential windfall that casual staff who only work a reduced number of hours during the course of the week would otherwise receive? So if we just have a look at the different options available, so you've got the standard variable hours contract that runs throughout the year. Those individuals are retained year round, and the Brazel judgment shows that if you're retained on that basis, then you are going to be entitled to 5.6 weeks pay per year. And so that sort of arrangement lends itself to staff who work consistently, who have quite a lot of hours, albeit they might fluctuate up and down with demand, that their presence in school is needed throughout a lot of the year, rather than being a specific requirement at a specific time. So those arrangements still have their place, and there are benefits in the sense that you wouldn't have to repeat onboarding processes for staff and say for recruitment checks, but you might want to review perhaps using fewer casual staff to do more work to ensure that the amount of time they're putting in is more equitable to the 5.6 weeks holiday of a full-time member of staff. So as I say, variable hours contracts have their place, but it's thinking about your arrangements and do they fit with that arrangement. If we move on to the next slide, please. Fixed term contracts. There's an option with a fixed term contract if you know that you've got a specific requirement for a short period of time for a particular type of worker, that a fixed term contract might be the most useful way forward, because their employment is going to be for, if it's going to be 2 or 3 months, it's less than a year. And the working time regulations allow you to prorate holiday in the first year of employment and to pay an employee on exit for their accrued but untaken holiday. So you can apportion holiday to the amount of the year that they've worked. So if they've worked for 3 months of the year, they'll get a quarter of their 5.6 weeks entitlement. And in that way, you could limit the amount of holiday that they're accruing. But this works only in circumstances where you know that there are short-term demands and not where you're going to be frequently reusing that particular worker, because in some cases, continuity of employment can be established. They would be entitled to certain rights as a worker with continuity of employment. And if the arrangements that you're putting in place are just simply designed to move you away from paying statutory holiday, there are implications that perhaps you're treating that fixed term worker less favourably than someone on a full-time basis or permanently engaged, and there are other issues. So they're not to be used to or abused to circumvent statutory entitlement to holiday. They have their place in terms of those short-term appointments. So someone doing exam invigilation, for example, who's coming in maybe for a month of the year to do that, it may be appropriate to offer them a fixed term. And then the final kind of contract that I wanted to talk about is umbrella contracts. So this is quite an interesting area, and one that there has been some case law on and is likely to evolve further in light of this decision. So an umbrella contract would work where you have a bank of staff who you have demand for from time to time, and you have an overarching contract that sets out the terms that you would apply if they're offered an assignment to work for you, and that assignment is accepted. So at the point they take the assignment, there would be an employment relationship in place. They would accrue their entitlements, entitlement to statutory holiday being one of them. But when they're off assignment and not needed, then they're not in an employment or a worker relationship, an ongoing relationship as required under the Brazel judgment, and so wouldn't accrue holiday during that time. And so there's an opportunity there, a bit like at the end of a fixed term contract, that you would pay in lieu of accrued holiday that they've become entitled to during an assignment. At the end of that assignment, then the relationship would go on hiatus until such time as another assignment's offered. And there was a case involving the National Nursing Midwifery Council that established that overarching arrangement, if carefully crafted and well drafted in contracts, can create employment in sort of pockets of time when on assignment. And so that might be a way of managing arrangements going forward. So overall, looking at the different type of contracts, it will be a balance between financial savings against inconvenience of repeating staff onboarding processes, and looking at what contract works for the type of work that you need to have undertaken. And so whilst there may be some inconveniences around onboarding, if you're looking at, say, for recruitment checks, some but not all of those checks might need to be redone in between new assignments, and use of the DBS Updater service, for example, might help with the administrative burden of some of those checks. So we've got a poll for you here. Have you received any queries from staff about the Brazel judgment yet? Let's say a yes or no poll. So if you could answer those questions. 84% say no, which is potentially positive. It may well be because we are currently in the summer holidays, and those questions may be deferred until staff return to work. Certainly there's been a lot of interest in the judgment. It's been well publicised, and the sector has been waiting for it for some time. So I would anticipate that those questions will come in, and hopefully what we're saying today in this webinar can help you be in a position to respond to those. And so if I hand back to Simon now, he's going to take you through some of the strategic considerations.
Thank you, Jo. That's great. And I think it's just, I just wanted to make two comments really. So for those of you who have the umbrella type of contracts at the moment, you will probably appreciate that the way they've typically been designed in the past is to ensure that you don't have to keep repeating the reappointment checks when staff come in and do hours and do work. So if you currently have some type of umbrella arrangement, or you know, often referred to as some kind of bank staff type of arrangement, you probably will need to not only review those contracts, but even to think about replacing them going forwards, if that's an option that you wanted to explore. As I say, the contracts were drafted for a different purpose in the past. And in terms of staff comments about this so far, I do anticipate that there will be a real trade union campaign in the autumn term seeking to get pay and increase pay for staff. So if you haven't been contacted by many staff so far, I would anticipate that you will be in future. So you're always better to get ahead of the information curve and to be deciding your strategy now throughout August, with a view to communicating about it in September. And if you, I was a little bit surprised, one client who went straight out actually after the judgment and said we will be paying 2 years back pay to everyone. The only response they had to that was, oh, but I thought it was 6 years back pay. But I will comment on that in a moment. So on this slide, you'll see next steps. This is really all about, and I'll go through some slides talking about underpayment and what to do about it if you have. But I noticed some of you, the idea of paying, you know, backward-looking compensation for underpayments may be frustrating. But I just thought it's worth just dwelling for a moment and just reflecting on what would have happened if back in 2013, when this point was first raised, and actually 2014 when we had some resolution at the employment tribunal stage, which Brazel lost the claim, if in fact at that stage the sector was being asked to implement the Brazel decision now, that we have now, back in 2014, well, let's just work on some simple figures. If the changes now require, you know, will cost you £10,000, well, back in 2014, you would have had to go back 6 years to compensate all these, you know, anyone who's been underpaid. And in fact, there's a good argument you might have had to go back to the year 2000 when the working time regulations were first entered into force. So that could have cost you at that stage at 2014, £60,000, or even potentially worse, £140,000 to correct at the £10,000 a year of cost. So then from 2014 now, that's projecting forward another 8 years. And again, at a £10,000 a year cost, that would have cost you another £80,000 to get to the point we're at now. So the point we're at now, if it had been resolved in 2014, it could have cost you anything from £140,000 to £220,000 to this date. Well, I'm going to advise you in a moment that you only have to consider underpayment and potential compensation going back 2 years. So that means it will only cost an employer first faced with this issue by £20,000 back pay in that for any potential claims, and then you resolve it going forwards. So really, the fact we're at this stage has avoided a large amount of that potential cost. So I suppose the question is, have you underpaid any of your staff who are now entitled to 5.6 weeks holiday pay at the rate of a normal week's pay? Well, if you've calculated for any part-year worker, anyone who doesn't work the whole 46.4 weeks, if you've calculated their holiday pay on the basis of the ACAS and government guidance of a 12.07% calculation, well, then there is an underpayment. There's no doubt about that now. I know some schools may sometimes pay a higher percentage, 14%, for example, if they're paying, an extra week's holiday, they give a week off, an additional week over Christmas for a shutdown. Well, then that's 6.6 weeks. That would be paying, that would be the equivalent of paying 14% holiday pay, wouldn't it? So still less than if like Mrs. Brazel, you worked a 32-week term, but actually the underpayment may be smaller than looking at the 12.07%. So you do have to review those contracts where you've been paying people on an hourly rate basis, or they've been casual, irregular hours, to see what that underpayment is. The next question then is always, what about those who have a salary and the contract wording may say that they're entitled to the statutory minimum holidays of 5.6 weeks? Well, if it says that in the contract, you may take some comfort from that, and it may be that the position for you is fine. So someone who works term time only, and you say, and they get the statutory holiday, or they get the referred to as the 5.6 weeks holiday, well, that position may be fine, just so long as if you check, as always, it's good to check just to make sure that you're actually paying the national minimum wage, not just for their hourly rate, but for the extra 5.6 weeks holiday pay that they're receiving. So you have to do calculations there to check that out for salaried. But what you may find as we move on to the next slide, that whilst the contractual wording may be good for you, it may not be so straightforward. And this is where really it is necessary to undertake a review of what I like to think of it of is a secondary level of decision making. So the contract itself may have said you're entitled to your 5.6 weeks holiday leave and pay, but it's then when the calculation of that salary is being undertaken, it may be that there was a consideration of an hourly rate. It may be that there was a prorating of the holiday entitlement, and it may be that there was a 12.07% calculation used to come up with that salary level that's being used. Now, if that is the case, I suppose you may start off from thinking, well, the contract says they get their full holiday pay, so I'm just going to leave it at that. I anticipate it won't be so easy just to tough that position out. And it will likely be the case that staff will be advised to question the means of that calculation and to ask you to look at what paperwork was in place at the time to establish how that calculation was made. And if that paperwork or the payroll system does exist that records it as being on 12.07%, well, you can see how that would have to be disclosed as part of a grievance or as part of litigation. And so the contractual wording itself is not necessarily the end of the story. Again, going back to this idea of toughing it out and just saying, well, you get the holiday pay that's recorded in your contract and that's the end of the subject. Well, I anticipate when you're being audited next time, you will be asked by your audit partner as to how you've calculated the holiday pay entitlement for term time only staff and atypical irregular hours staff. And they will want you to make provision for any latent liability in there. So I would advise you to do a proper review and work out the actual level of risk in respect of each contract type and the potential liability for it. Because it's only once you've undertaken this review that you can consider your strategy of approaching this with staff. And I imagine part of that strategy will be going to those staff who are affected and explaining to those who are not affected why not. Okay. So in doing that review, you'll identify if any contract wording needs to be changed or clarified. That may be the case, but it may be that it's at the top level, the contractual wording, say statutory holiday or 5.6 weeks holiday, it's the calculations that lie underneath that are what we'll be thinking about more. Managing costs, it's something that lots of people ask us about. And I suppose there are unintended consequences, aren't there, in cases like this? Because I cannot stress enough, really, that this judgment is not about an unscrupulous employer who's trying to deprive their workers of rest and pay. This is about employers who, in good faith, used the calculations recommended by the government and by ACAS. So I think if you look at it in that way, you may think that this is a windfall for those staff, although do forgive me for those of you who would disagree with that suggestion. So unintended consequences, Joe's considered them, the idea of discrete contracts, short contracts, and it is worthwhile just looking at how you do that holiday pay calculation in that situation. So if you had, if someone's in their first year with you and then their employment ends, well, let's say you take them on for a half-year contract. So you wouldn't apply a 27.07% calculation anymore. Let's move away from percentages. What you would do is you would say you work half the year. A permanent member of staff working all year round gets 5.6 weeks holiday. You will work half the year and you will get 2.6 weeks of holiday and pay. And that is perfectly acceptable to do in the first year of someone's employment, and to use kind of short-term discrete contracts. We've got there as a second bullet point under this heading. I think it is a shame, but I know some employers who will think again about agreeing term time only requests, and it may be that form of contracting is used less and that people will work a few more weeks than they have done because the school will say they need continuity of people being there. And of course, that may well reduce the weekly pay rate that is then used for someone's 5.6 weeks of holiday. So I can see that's been a practice that develops. We say there about incorporate additional holiday pay into pay review. Well, you need to be transparent when you're doing something like that. So if you're saying to someone now, look, we're giving you a 10% pay rise, well, unless you talk about how you deal with this Brazel judgment and how you're increasing it to take account of the additional holiday pay that they're now entitled to, you can imagine them saying, thank you very much for that pay rise. I now want to ask how you're dealing with the Brazel judgment, and I should be getting, still getting additional holiday pay entitlement. So you've got to be careful how you deal with that. And I think, sadly, the final bullet point deals with visiting music teachers. And I think it is one of the sad consequences for VMTs, and it really does go to suggest maybe this was a Pyrrhic victory. Because if you as a school merely say, this increases our costs, so we're going to increase our costs for tuition lessons for visiting music teachers, well, then it may be that parents are less inclined to have music lessons with your school and maybe more inclined to get them outside, which of course would be a shame for visiting music teachers, but you could see how that could be a response to this change that the Brazel judgment brings in. So now I've mentioned back pay a lot and referred to it. I just wanted to confirm to you that it, next slide please, that it is the deduction from wages, in brackets, limitation, close brackets, regulations 2014, which introduced from July 2015, that for wages claims like this, you only go back 2 years to compensate for any underpayment. So that is helpful. You'll see, so 2 years back pay is the limit that you will need to go back if you have been paying some holiday, but it's been underpaid, so that's 2 years limit. But we've mentioned here the Bear Scotland case, and of course I've mentioned how the law's changed over this period, hasn't it? And there's been multiple decisions which impact on what we're looking at now. In the Bear Scotland case, it said that if you have an underpayment of holiday or any contractual underpayment, you have to bring the case within 3 months of the last underpayment. So, for example, if you only paid holiday once a year, so you did your calculation and paid it in July, well, someone could bring a claim now with you for the last payment that you made in July 2022, but because the previous payment was in July 2021, there would be more than 3 months' time that's elapsed since, so they would be out of time to claim for that second year of underpaid holiday pay. You can see how that will work as well when you pay in 3 termly instalments, and again there will be at least one break in the year where there's been more than 3 months since the previous payment. So on the face of it, we should be advising you that rather than go back 2 years compensation, please review and assess whether you need to, you can break that and compensate for a lesser period. Well, that would that would be a good position to be in, but I'm afraid in a recent case in 2022, a case called Smith and Pimlico Plumbers, for those who want to look at it, in the Court of Appeal, the Court of Appeal expressed a strong provisional view that this 3-month rule will not survive. Now, depending on your appetite to risk and how you want to play this, you can refer to the Bear Scotland case when communicating and talking to staff about how much you compensate them for any underpayment. But I can assure you that Smith and Pimlico Plumbers will be referred to, and staff will expect 2 years back pay if this is something that affects them. And there will inevitably now, the Court of Appeal in Smith and Pimlico Plumbers, it wasn't part of their requirement to decide on this 3-month rule and the break, but they couldn't help but comment on it themselves because there'd already been a case called Agnew in the Northern Ireland Court of Appeal that thought that this rule shouldn't apply, and so they commented on it, even though that case didn't get to the Supreme Court. So I see satellite litigation about this, and it does depend on your appetite to risk as whether you want to try and limit your back pay in cases of this type. Next case, please. So, next slide, please. Sorry. So, what is your views on the best commercial approach to back pay? Well, what I hear is the amount of time and cost that may be involved in carrying out precise calculations for individuals. So, of course, that's the only way that you will be able to make an accurate assessment of what underpayment is due in terms to compensate any individual. But I can see why some will be thinking about, well, can we just work out a percentage figure that exceeds the statutory minimum? And here we're talking about, you know, if someone worked, say, 32 weeks a year, could we say pay them 17.5% as they did in Brazel? Should we round it up to make sure we knock it out and be certain that we've overpaid on it? Well, yes, I'm sure that you can look at doing it in that way. I'd be interested to know what your views are on that and what people are thinking about it. And I think this will be a rolling conversation, actually. But you can do that and exceed the minimum. The problem will be is you may still get individuals who want their figure to be individually broken down and assessed. And they may think that there's that the underpayment for them has not been properly reflected, and it may be that you've got to go through that calculation. And again, it's something that you may review, and you may be thinking about whether you offer a set percentage, or you do individual calculations, or you offer a set percentage and see what happens. But we will be writing about this and talking to people about it, and we will let you know and any greater intelligence we get about that. And I'd be delighted to hear your views on it as well. If you've got trade unions are involved with staff who are affected, you may wish to speak with them as well. And it's all about, isn't it, making sure that you deal with this as simply and as well as you can, and with as least fuss, but recognizing that that there is quite a bit of work to do. Going forwards then, where you have regular monthly salaries, you just need to be clear, don't you, that someone is getting 5.6 weeks holiday and that it's paid monthly and paid accurately. That's something that you will need to review for all salaried staff. Variable staff with variable hours, well then you'll need to review when you actually pay their holiday pay. Because of course, as Joe said earlier, you have to calculate, when you pay holiday pay, you have to calculate over the previous 52 weeks and discount any week where they weren't working. So it could be anything up to 104 weeks to get your weekly pay calculation. So when you're paying holiday pay, it would be more convenient, wouldn't it, to do that in one annual calculation. Typically, I think it's done termly, and then you allocate some time. You'll say you take a week at Christmas, a week at Easter, and the balance will be paid in the summer holiday. But then you would have to do 3 separate calculations. So it's something, I think, it's not only when you're talking with staff about back pay, you're also going to be talking to them about how you pay holiday pay going forwards, and we'll want to discuss that with them. Now, I'm conscious that I'm running on over time, and I know there's lots of questions. I hope we've been answering some of them as we've gone along with our general presentation, but we will overrun because I think it is important, and I wanted to go through all the detail as we have done so far. So got a couple of slides now that deal with the employment contract. You'll see that in the Employment Rights Act Section 1, you'll all have heard of a Section 1 Employment Rights Act statement. Well, you have to cover holiday pay and how it's paid. So that's obviously the case that you'll have to cover it in the contract. We've mentioned, we've put in here what the contract should actually say, and you'll be pleased to know that we have been doing our employment contracts update over the summer for those of you who use our employment contracts and can access that on stream. It is a premium service. It is something that you get access to if you use some or all of our contracts, not just generally. But that's currently offline. We're just making another tweak or two to a couple of the contracts, but our contracts have been updated, and we're hoping to get that back online again in the next couple of days. So that's what you'll need to do. That for salaried staff, it's holiday pay will be included in their salary. It's just making sure that you've done the calculation correctly in the past, or at least doing it correctly in future with any necessary back pay. for the bullet point, those staff, for hourly paid and irregular hours staff, it is a question about when you pay that holiday. And I'm always conscious when you know, on the one hand, it would be more convenient to pay it in one go. I am always concerned about how that may impact on the cash flow of certain staff, and whether that would be necessarily too difficult for them, and they would prefer that paid on a termly basis. And if you were to do it termly, that may assist in the goodwill as part of discussing this all with them. So how will you communicate with staff? This is key. In September, I do. Sorry, and the next slide as well, Tamar, please. I think we're on the last slide now. Strategic. How we'll communicate with staff. I do anticipate a push by unions. I do anticipate lots of people will be asking you about it. We will be putting some frequently asked questions on stream when it's back up. But I would just remind you all that you may have to evidence how you've calculated holiday pay in the past, and that would be disclosable as part of litigation. So when you're deciding whether you are offering back pay to some salaried staff, you really only can resist that, I think, in clear conscience and with no risk, if you can evidence that you've used a calculation other than 12.07% in the past. And a little bit like people who don't pay the national minimum wage at times, I mean, the government has a website, doesn't it, where it names and shames them. I imagine the union will be targeting those employers who are not picking up any underpayments and settling, you know, getting this set up and paid right in the future. So how I rationalise this in my mind really is it is a windfall for those who work part year, so they don't work the whole year. I think the law, it's a shame that they didn't consider that the prorating principles in European law couldn't be applied. I don't think the government will get round to changing the law, although I think the law is poorly drafted, and the Supreme Court said as much. So you will have to manage this. It's not just a short-term situation. So I think my advice in terms of action points is that you review your contract wording, review how you actually did your calculations, consider how to calculate the back pay, and then clarify any contract changes, and consider how you communicate with your staff about any underpayments and rectifying them, and how you will pay it and when you will pay going forwards. I always think transparency and engagement with staff is key. I think there will be reputational issues for those employers who try to avoid this. And outside of the independent school sector, we can all think of those employers who typically end up in the press about trying to avoid paying people what they're right to receive. And I think in this case, it was genuinely the case that this was that this is an error in the law and drafting the law. So I don't think there's any reputational issues about paying 12.07% in the way it was paid. But I think going forwards, it is something that you will be looking to rectify. Now, I'm conscious with overrun. I think we have time limit on sessions like this, but we will now pause for any questions, and I think we can go on another 10 minutes before we run out of time. But thank you. And we've got Jess coming on now, who has been collating all of your questions, and we can now think about how we can try and answer them.
Thanks, Simon. Yeah, I think there's some common themes coming out of some of these questions. So perhaps if I just put a few to you, and hopefully they will mop up lots of the questions that people are asking. Great. So I think one thing that has come up quite a lot is, how do we tackle staff who've already left? So limitation periods for claims, and to what extent do we go about settling those claims?
Well, I think the starting point to bring a tribunal claim in the employment tribunal, it's 3 years. Jess, I
3 months, so the 3 months limitation.
sorry, did I say 3 years? Oh my word. One of the problems, hours, days, weeks, years, of course an employment tribunal claim is 3 months. So any member of staff who left over 3 months ago, there's no, I mean, I wouldn't be communicating with any ex-member of staff, actually. I'd wait for them to contact you. But if someone left over 3 months ago, well, then they would be out of time to bring a normal Wages Act claim in the employment tribunal. Can they bring a claim in the county court for Wages Act claim? Do they have jurisdiction to do that? I mean, they would.
Yeah, deductions from wages claims are usually employment tribunal claims, as well as claims for the enforcement of those deductions.
Yeah. So it would normally be the employment tribunal. I've not seen anyone try and bring it in the county court for, but I mean, I would be working on the basis of 3 months. If someone threatens to bring a claim within 3 months, well, then you'd want to be looking to deal with that. But if they've left more than 3 months ago, well, then I would not look to settle. But I suppose there is a risk they try and bring it in through the county court. But I wouldn't settle on that basis at this time.
Thanks, Simon. And then sort of linked to the urgency of all of this, several of the questions are saying, you know, this is a lot of work to do, and how urgent is it that all this is in place, for example, by September?
Well, I think there's a couple of points about that, really, aren't they? I mean, I suppose I would be wanting to let staff know when they come back in September before. I mean, I do think it will be a deluge of questions, and I would be wanting to be proactive in September and explaining to staff what you do. Now, that and I think they would be provided with great reassurance if you were to say, we are reviewing contracts, we are reviewing if there's been any underpayments, and if there have been, we will correct them from 2 years going backwards from now. And we will also be correcting it going forwards from now. And if there's any underpayment in anyone's current salary, we will be correcting that as soon as we can. And we will make, again, we will make back pay from the 1st of September going forwards. Now, technically, if someone's not satisfied with that, well, then a claim and the 2-year back pay doesn't crystallise until they actually lodge a claim with the employment tribunal. So they won't be disadvantaged. In fact, they'll be advantaged if you say to them, now we are looking to resolve it and you'll suffer no, we will settle it in terms of academic years, I think is a nice way of looking at it. So the last 2 academic years, we will resolve any issue. And that's not to declare and volunteer, who may have been underpaid. It's that it will all be reviewed. It might be that we want to say at that stage that all teaching staff, this doesn't apply to teaching staff, so you may want to narrow it, but I suppose it depends on how much work you can do between now and September. But I think being on the communication front foot is always the best advice. Thanks,
Simon. And some of the other questions are around how to recoup the cost of this increased holiday bill, and on a commercial basis where we might be looking to do that.
Well, there is a latent liability for all those who've been underpaid going back 2 years, and unless you try and apply the Bear Scotland rule and limit it further, and there will be an increased cost going forwards. So I think it's one of those where there will be a wider review of operations. It makes me think of the business cases that we've all been doing around TPS and continued TPS membership. you've looked at all the kind of general cost savings that you can make. You've looked at staff numbers. You've looked at many other things. If this is an increasing cost, it's a hit going backwards for up to 2 years, and it's an ongoing cost going forwards. And it might be that you are looking to increase costs, use fewer people. I think I hear different views, really. I think when it comes to things like invigilators, who you maybe only use for a couple of months a year, going forwards, you would be looking to have them on a short-term contract, wouldn't you, rather than just having it ongoing, and accepting that you will need to undertake recruitment checks again for them before they can start work in the following year. But I think for term time only staff, or the idea of working each term and then the contract ending and starting again, well, I think the onboarding process and offboarding process will be too time consuming, and you would end up, it would end up costing you more time and money than just recognising that there is an increase to those staff's holiday pay. But I think it's a wider commercial review of what schools do. I don't know if you've got any thoughts on that as well, Jo.
I think you've covered everything that I was going to say. I suppose the thing for music teachers would be potentially passing on costs to parents and other things in that nature. But I think schools are very adept at looking at ways of minimising cost and already have been doing that through TPS. So I think it's the same principles that will carry on.
Yeah, and I think it will impact on the way you view some flexible work requests, for example. It will impact on the number of parents who will have music lessons at school if the cost becomes unaffordable, and or so much greater than they can from engaging someone in the local community who advertises in the local newspaper. It may be that fewer lessons are undertaken through the school. Okay.
Thanks, Simon. We're just it's just after 3:10. This has generated lots and lots of questions. Lots of them are quite specific, and I would say, just as a sort of summing up to the Q&As, really, but so much does depend on the contracts that you've got in place, the wording of those contracts, and then also the category of staff that you're looking at. So whether it's people who have got normal working hours and there's to be variations of normal working hours, or indeed, as Mrs. Brazel was, whether it's a worker with no normal working hours. All of that goes into determining how to approach holiday pay going forward. So it is quite complicated, and it may be worth speaking to us on an individual basis, I think. Simon, would you say, for individual advice on some of these questions?
I'm afraid I think it is inevitable, because contractual wording is different, and even where the contractual wording is let's say perfect, it still depends on the practice that took place behind that, in how you came up with salary payments or hourly rates. And so each case does depend on its facts, but I think that I hope we've given a good amount of guidance today as to how to undertake that review and what you need to be looking for. And I think to identify the holiday pay clause and payment clauses in a contract, and to look at your the practice of what sits behind calculating that, I think it would be a good exercise to review that, to see which members of staff are affected, before you go back and start actually then trying to calculate the underpayments for the individuals. So to start at the kind of strategic level and then work down into the detail. But I mean, in response to the theme of the question before, Jess, I think, I don't think there is a quick answer to this, and to how you work it all out and resolve all the work. So I think to prepare as a first step as well, the communications with staff to say, look, we've got this in hand, we're looking at it, no one will be disadvantaged because we haven't come back and advised you, on day one of the term, what any back pay could be, or, how we will change your pay calculation going forwards. But this is a standstill moment, I suppose you could call it, couldn't you? Where you will, any back pay you're entitled to, we will ensure you receive it for the last 2 years, and we will resolve it going forwards. And you would hope, although I'm afraid some of us are never cease to be disappointed, that if you communicate in that way, that staff will accept that and see this as a bit of a windfall, and be pleased that you are looking to sort it out. But we will see.